Good evening, friends. Thank you very much for joining us this evening. I'm sorry my video isn't on. For some reason, my laptop isn't cooperating tonight, but here we are. At least I can see Lars and the rest of you. It is not a personal affront to anyone that my video is not on. I'm live and very happy. Let me introduce Lars very quickly. He asked us to keep it short and sweet. Lars is a trust and estate attorney in Washington, D.C., a second-generation four-year-old graduate of the class of 1983. That puts him in Jamie Zavit's class, and I believe also Joel Rockwell, and I believe someone else very close to Joel Rockwell, but I won't go there.
One year ahead.
1 year ahead. So there we go. And so Lars also served on the board of trustees of Only Friends School and was the treasurer right before he cycled off the board. And for me, very specially, he was the chair of the search committee for the head of school at Only Friends School when I applied for the position. So if anyone is not satisfied with my performance, please blame Lars. Lars, over to you. Thank you very much for accepting our invitation and for being here with us this evening.
Well, thank you, Christian. Certainly serving on that search committee with Mimi, who is on tonight, I see, and other members of the board was a highlight of my service to the school up until that point. Let me also add that I've had a number of cousins be four-year students at Olney. And when I was on the board, my dachshund Ada was officially designated the board dog. So I think that's also an important highlight. Now, we have some disclaimers. And one is that we're going to be providing, or I'm going to be providing, general information this evening and not legal advice that's based on any client-attorney relationship. And the other thing I should add is that much of what we are going to be talking about is state-specific. And so I'll try and highlight where those variances are. And so, Anne-Marie, if we could have that first slide. I understand that she's using the chat feature. So if you know how to do that, you can type in questions as we go along. And also the hand raising feature is going to be used as well. So let's go to the next slide. All right. So what are we talking about tonight? We're talking about your stuff, your worldly assets, and we're talking about your physical stuff, your tangible stuff. We're also talking about your intangible stuff. We're talking about your money, and if you have patents, and if you have intellectual property, but we're also talking about your Picasso and your stacks of coins in your collection. And what often I'm asked is, should you have a will? Should I have a will? Don't worry if you don't, because the government is going to take care of it. It's called dying intestate. And if you don't have a will, every state in the United States and the District of Columbia has a statute that says what happens to all of your worldly assets, how they're divided. And in 99.9% of the time, it's probably exactly what most people do. But if you don't like all of your children, or if one of your children turns out to be Bill Gates and doesn't need any more money, or, you know, you're doing something else a little different, you might want to have a will in order to establish that which you want to do. You know, if you want to give it to your best friend or to your lover and not to your wife or to your husband, a will might be a useful thing to have. Now, you have in your bundle of assets two categories upon your death. You have your probate assets and you have your non-probate assets. Some people say you have a probate estate and you have a non-probate estate. Now, what's a probate estate? A probate estate is something that requires a signature in order to make the transfer from the dead person to whomever the dead person wanted that asset to go to, if there's a will. Similarly, if there's no will and a signature is required in order to transfer an asset from the person who died to the person designated on the statute, that's a probate asset. Typical examples, your car title. If today you want to sell your car, you have to take the title, you write your name on it, you sign your name, you write the name of the new buyer, he or she signs his or her or their name on the title. Real property that's titled in one person's name, same thing. You go to sit at that desk at the title attorney's office and you sign volumes of paper. Signatures are required. Bank accounts that don't have a beneficiary designation. They need someone to go in, give them the passbook. No one knows what a passbook is anymore, but still give them a piece of paper or withdraw a slip and withdraw money and give the money to someone. All right, so what's not a probate asset? Well, that bank account where you've put someone's name on it so that when you die, the moment you die, that automatically passes to the person or people or institutions, and we'll talk about that, whose name is on the beneficiary designation. Also, real property. So if you bought your house with someone, a spouse or a best friend, then that was probably titled tenants in the common or tenants by the entirety. Those are slightly different. We can go into that if anyone has questions. But upon death, the successor automatically gets that interest in that property and signatures not required. Also, assets in a trust, and we'll talk about trusts in a second. So these are the two types of assets that you have upon your death. And as you can see, maybe, it's conceivable that you may not have a probate estate upon your death. So my mother, when she dies and she's well down the path of dementia, she no longer owns a car, she no longer owns a house, she has bank accounts and she has brokerage accounts, all of which have beneficiary designation on them. And so when she dies, there will be no probate estate. Likewise, folk who starting out, right out of college or in high school, you probably don't have a probate estate because you don't own anything. And if you do have a small bank account, hopefully you've put a beneficiary designation on. So it's kind of like a barbell at both ends may not have probate estates, but it's kind of the folk in the middle who are more likely to have a probate estate. So can we have the next slide, please? All right, so what's in an estate plan? These are the typical documents that one should have. First, I do think you should have a last will and testament. Don't leave it up to the government. Now, should you have a trust? And there are different types of trusts. There are revocable trusts, so that the grantor, you, when you set it up, you can change it throughout your life. And if you change your mind, you can say, no more trust. There are irrevocable trusts. Once you set up the trust, it's there. Now, why might you do that? You might do that if you have a lot of money. There are about 3,000 people in the United States a year who die owing federal estate tax. That means they have over $12.6 million. And if they're married, $25.2 million, because there's something called portability. If you have that much money, and actually you really should have even more than that, because it's pretty easy if that's all you have to shelter that from tax exposure. But if, let's say, you have $100 million, it may make sense to put 50 million of that in an irrevocable trust so that there is no estate taxation exposure to that 50 million. You have estate tax exposure to 25 of the remaining 50 million, because 25, if you're married, there's no exposure because each married person gets 12.6 million. You can understand why there may be reasons how you might want to structure an irrevocable trust. But if you're in that situation, call me tomorrow. I'd love to talk with you about that. I think we'll spend more time on folk who don't have that much money, and why might they be interested in having what's known as a revocable trust. Traditionally, it was because probate was difficult, and it still is in some states. Unfortunately, in DC, it's really easy. It probably costs you more to establish a revocable trust than you're going to save in probate. So for most people in DC, it's not worth doing a revocable trust. In other states, now let's go stay on that first slide, the slide before. Nope, you're going the wrong way. I got thrown. Yes, okay, thank you. I need my cheat sheet. Why might, what are some reasons? So think of a revocable trust like an umbrella. You, the donor who is establishing the trust, are holding this umbrella. The umbrella is open, and there are those ribs on the umbrella, and you put your car title on it, you put your house title on it, you put your bank accounts on it, and the moment you die, the successor trustee grabs the handle, you fall to the floor dead, and all the stuff that's in the trust remains in the trust. And somewhere in the trust, it should have provisions what happens as soon as you fall dead and land on the ground. So that's pretty seamless. There's no probate, there's no signatures required because it's already established under the umbrella what happens. So if you're in a state where probate is difficult, it may make sense. Another reason, a will is a public document. So if you're hypersensitive about privacy, that might be a reason. Most people's wills aren't particularly granular. And so, you have to be really hypersensitive about privacy, I think, for that one. But a trust is not a public document. It's not publicly searchable. Another reason, and this is why I eventually and my husband eventually did a revocable trust, is we own property in multiple states. And so it is easier in order, remember this umbrella, it is easier instead of having to open property in open probate, in multiple states, it is easier to transfer properties under the umbrella. And so I think that, at least for folk in DC, is still a very valid reason. The last fairly valid reason for many people is if they have kids and they die and they're worried about their spouse maybe spending the money, the successor spouse, spending the money on the tennis pro instead of paying the Alney tuition. And if that's the case, if you're concerned about wives and husbands and spouses and tennis pros, you may want to put your money in a lockbox, an Al Gore's lockbox. And so then a trust is a means of locking up those dollars. All right, so what else should you have? And let me say that for a last will and testament, you have the responsibility of picking someone to be that signature. And we call that person nowadays the personal representative. It used to be called the executor or the executrix, but we now call it personal representative, so we don't have to worry about some of those sexist terms. This person should have two major traits. One, they should know how to use Excel. Now, I don't mean that figuratively, but they need to be able to keep track of what goes into the estate and what goes out of the estate. Because basically what this person does is make the specific gifts that are in the will. And you can say this also for a trustee, make the specific gifts that are in a trust. And then the person has to be able to communicate. Well, the house didn't sell because we found nuclear waste in the backyard and we had to remediate it, and it took us 6 months, and then houses don't sell in this market until next year, next autumn. And so to be able to keep people informed of what's happening with an estate is very important, because when people don't hear and they know they're in an estate and someone's administering this money, many times ill will is formed and fosters. And so it's really important that whoever you pick to be your personal representative or to administer your trust upon your death is really good with communicating and keeping everyone informed. All right, healthcare power of attorney and advance directive. You might have one of these, you might call it a living will. I hate that term because I think it confuses people with their last will and testament. So healthcare power of attorney, advance directive. Some people do this as 2 documents. I think that's weird. So I do this as 1 document. Why have a separate power of attorney for health matters and then have a separate document that tells you what the standard is? But anyway, some attorneys still do this as 2 documents. The important thing here is that the person you pick, you have a conversation with, and he, she, or they does what you want, which may not necessarily be what he, she, or they would do for him, her, or themselves. And so it's important to have that conversation. It's also important to make certain that you use the right document. So you can go online and you can find actually any of these documents online. The question is, do you know which one to pick? Healthcare powers of attorney are promulgated by all sorts of interests. You can find ones promulgated by the insurance industries. You can find ones promulgated by the hospital industries. They have one called the 4 Wishes, and it's all about not getting sued as a hospital. So you can find all sorts of documents. Just, have a conversation with the person who's drafting it so that they appreciate your perspective, and that perspective is actually incorporated into the document. General power of attorney. This is the power of the pen again, except while you're alive. If someone knows where your money goes, they know everything about you. You can't hide. So this is the document that if you can't pay your rent, if you can't pay your mortgage, if you need assistance, not that you don't have money, excuse me, it's if you're physically unable to pay, your general power of attorney allows someone to do these activities for you. So what's the important trait here? You trust the person because they're going to have your money. And 2, if they learn everything about you, you're not going to be embarrassed, or at least the embarrassment's not going to last forever. All right, disposition of remains. This is a document that says what happens to your will. What happens to your body when you fall down dead. All right. Many of you probably have somewhere in your will a provision that says what happens to your body. The problem is a will is not a binding legal document until it goes through probate. And most of the time you're in the ground already or you're burned up. And so it's a good idea to have a separate document. It's especially good to have a separate document if you have people who are going to fight over your body, because then you don't want it to be who gets the body first. And this happens if you're in a marriage or in a relationship where different people have different religions, or where you're not accepted by family members. It unfortunately happens that there are races to get to the body. And so some states, the District of Columbia is one, but there are states that allow for a special class of agent to be directed and have control over the body. And if you're in one of those jurisdictions, I think it's a great idea to take advantage of it. It's also really the kind thing to spend some time while you're alive thinking about what's going to happen. And please do say more, write more, have written more than I want to be cremated. Because if that's what you do, someone is going to be handed either the plastic box, it's gray plastic normally, or a cardboard box, and then they're going to hold it in their hand. And just an interesting fact, we all weigh about the same when we're cremated, and then they're going to look at this thing and they're going to go, now what? And you might end up like my father, 15 years in my hall closet, because my brother and I had no idea what to do. And finally, we've now kind of hatched this plan for after our mother dies, what we're going to do. But it's really a nicer idea to give people some idea beyond just bury, where, or cremate, what to do thereafter. And finally, HIPAA. We've all heard about HIPAA the last few years. Most of us don't even really understand what HIPAA is about. It has nothing to do with me telling your best friend about your medical condition that I've heard about. It all has to do with medical providers telling people about your conditions. And in this case, we want it to be that they can tell all of this cast of characters of your agents, whether you're going to live or die, so that they can make wise decisions on your behalf. So that's what's in an estate plan at the very highest level. And now we're going to go and talk about some of the more fun stuff. The next slide, please. I love this slide. You know, in this age right now when there's so much friction and so much suspect of people's motives, and we're all thinking that people are trying to game the system or to do something with less than full integrity, or some people think that, I should say. I just think this is marvelous that, you know, the most kind of opportunistic reason is the last reason. But the number one, let's keep on that slide. But the number one reason, you believe in the mission, they tell you what they're doing and you believe in it. That's why you give, you know, combine those first two, and that's a really, I think, startling number. So who gives? Next slide, please. Yeah, so it's people who have silver highlights who give by and large. You know, and so it actually kind of weaves in well with the first part of the presentation. All right, so how can you give? Next slide, please. All right, leaving legacy. All right, so this is how you can give as part of your estate planning. First one, non-probate assets. Remember, beneficiary designations. Take your bank account. Well, actually, you go online nowadays, your brokerage account, and put the Tree Huggers Association of America or Only Friends School or whatever charity it is that you love, and give them something. Now, if you have the option, it is best to give IRAs, pre-tax IRAs, to charity and give cash to people. If you give a charity an IRA, a pre-tax IRA, it is the only dollar you will have ever earned that will never be taxed. Now, you don't get a tax deduction as a consequence, your estate doesn't, but still, it is fabulous. If you give an IRA to a person, and it's not your spouse, he, she, they have 10 years in order to withdraw it. They can take it all out the first year, they can take it in 10 payments, they can, however they want to do it, but after 10 years, the money has to be out of the IRA, and yes, they pay tax. If you give them cash from your checking account, there's no tax owed to a person. And so it really is better to give $5 to a charity from your IRA, no taxes ever paid, or $5 from your non-IRA account to people. Wills, pretty simple. You can put, and I should say for beneficiary designations, for both of these categories, you can put percentages or you can put specific dollar amounts. I personally like I like percentages because hopefully you get more money over time. And so you don't have to revisit, but you can do either. Wills, it's a probate asset. Remember, signature required. Again, you can leave legacy to institutions by putting in. One of the things for a will more so than a beneficiary designation, because the beneficiary designations tend to give you less space, is that in a will, you can be a little bit more directive often as to what you want that charity to use it for. Now that can be dangerous though. I notice Anne-Marie cringing a little bit because you want to talk to the charity, you know. Let's say Only Friends School, you want to give $1 million, but you want to give it so that the school can study bumblebees. That's probably not a good fit for Only Friends School. And they may actually have to say, And then what happens to your $1 million? If you didn't do the planning correctly and you have someone else to get the $1 million, then boom, we have an intestacy situation. So you don't want to do that. You want to talk to Only Friends School or the Tree Huggers Association of America or your favorite charity and kind of, you know, have a conversation with them. And hopefully you're a good donor and you have a relationship and you really know what they're interested in, but even not, it's still a good idea to have that conversation. I'll tell you, you get treated really well by most charities when they know that you're going to give them something. They probably will have a tea or a coffee, or you'll get a little book. You'll just deepen that relationship. And interestingly, people who are members of legacy societies give more money thereafter, annual giving wise. So it's true, you really do deepen your relationship. Trusts, you can name a charity in a trust, just like you did in a will. Unneeded life insurance policies, if you have one, if it's fully paid up, hey, it's a great thing to do. Give it to a charity. It used to be that that life insurance policies were used in same-sex coupledoms before marriage was alive in order to pay estate taxes. State taxes used to be like $500,000. So a lot of people had much more exposure to estate tax. So in the same-sex world, there's a lot of, there are a lot of unneeded life insurance policies nowadays. And so there are a lot of very sophisticated charities that are kind of going after that money, but even other folk have unneeded life insurance policies. I'm just going to touch very briefly on the thought that money is really composed of two parts, principal plus income. And so depending on the sophistication of a charity that you're interested in, they may separate those two. They may have programs where you give them money and they give you income for a number of years, or they give you income, or you give them principal and they give other people income, or they give you income for a number of years, but then at the end they take your principal. So, or they give your principal to someone else. And so depending on, the relationship that you have, the amount of money that's in play, the size and the sophistication of the charity, there are some opportunities where you can get an income stream, or you can give an income stream to someone else, and the charity of your heart's desire at the end gets money, or the inverse, the charity gets money for a while, and then in the future, someone else gets principal. All right, next slide, please. Oh, bottom slide, of course, most important. And I think we'll show that again at the end. All right, next slide, please. All right, so remember, this is living legacy, so it's not all about when you've hit the floor dead. You want to give to your favorite charity today. The market, stock market is continuing to go up. It's had some hiccups, but still statistically over time, is performing very well. So that stock that you may have bought for $5, that's now worth $100,000. And if you want to give a charity $50,000, or hey, let's say the whole $100,000, a really good thing to do is to give them those shares of stock that you only paid $5 for, because you're not going to have any tax exposure on that. You're going to get the full $100,000 tax deduction, but you will not have paid income tax on it. Way smarter than taking that $100,000, going to your broker, or no one goes to brokers, but anyway, selling the stock, paying your long-term capital gains on that stock, and then giving $100,000. You're going to have to get some other money to get to your $100,000, giving it to your charity. So gifts of highly appreciated assets. If you have a Picasso on the wall and the charity accepts Picassos, that's also a good thing to give. All right, gifts of art, really problematic. Don't do it unless, anyway, call me. All right. Remember the slide about who gave? Well, IRAs, perfect sweet spot. IRAs while you're alive. So you have to be 70 and a half, $100,000 total limit. The next two are the ones that sometimes trick people up. You can't get a benefit from it. So Olney Friend School cannot give you front row seating at GymX because you have made a significant donation out of an IRA. The more likely is that the college football team can't give you access to donor suites. And the gift has to go directly from the IRA administrator to the charity. So you can't withdraw, take the check, endorse it over, and give it. It actually has to be cut directly from Fidelity or from wherever your IRA is and go directly to the charity. And what you do is you send an email to Anne-Marie or to your favorite Tree Huggers of Association gift planning officer, and you say, I am going to be making an IRA donation. And the check actually has your name on it, or the electronic funds transfer, and it will be matched, and you will get that marvelous feeling and the thank you letter, but just you won't get the coffee mug. No income tax deduction, but you have never paid income tax. So it's a pretty good deal, and it counts towards your RMDs. So, you know, if you don't need your RMD for cash flow as a retired individual, at least give that away, I would suggest, because then you don't have to pay income tax on that RMD. And our last slide. So, hi, I'm Lars, and you have my contact information. And after we're done this evening, if you have any follow-up questions, we're going to do some Q&A, but if you have any follow-up questions, you know where to find me. And most of all, please join me in supporting Olney Friend School. I certainly think it's a worthy endeavor and have been pleased for many years to give to the annual fund. And I hope that you do that as well.
All right, we're opening up to questions. You may raise your real or virtual hand and unmute yourself and speak.
Oh, I didn't say what this thing is behind me, and it's not that I'm a fan of The Lion King. So Christian will know, and Anne-Marie has been to my home, and some other folk have. On each side of my front door, there are lion gargoyles, and I work from home. And so that became the firm logo.
Zeppo has a question. Zeppo, please unmute yourself and speak.
So it's not my question, it's Clive's.
Good. Go ahead.
So how can you change your, I guess, partner's will and put your name in it?
Okay, let me make certain that I understand the question. So you're asking if there's an existing will from someone else, can a third party take that will and change it?
Yes.
No, that's a problem. That actually is a criminal offense and is a big no-no. We go through efforts in executing wills to prevent just that scenario from happening.
Thank you for that great question, though. Who's next?
I suspect that Mimi has taught some mystery fiction where something as dastardly as that has happened and then led to the dead body in the closet.
May we ask everyone, please introduce yourself first before you ask a question. So I'll go ahead and introduce Clive Mugisha, who is a junior from Uganda.
Lars, I have a question. If you have your trust put together some years ago by a lawyer, oh, by the way, I'm Mimi Gamble Kramer, class of 64, and fellow board member of Lars's. And that lawyer has stopped practicing, joined another practice. You're not sure where the lawyer is. What should you do?
Okay. So I'm going to answer that, and then I'm going to answer another related question as well. Okay. So a trust and a will, neither of those documents go stale. So as long as the cast of character who are doing stuff within the will, the people who are actually doing or getting in the will or the trust are the right people, are still the same people, you haven't changed your mind, then a crinkly old trust where that onion skin paper that you can, you know, and the same thing with like a will drafted years ago, hey, it's fine. So, you know, as long as, again, the people who are serving as successor trustees or serving as personal representatives are the right people, the people you still want. The people or the institutions that are getting are still who you want to get, fine. Now, those other documents, the powers of attorney, they do go stale. So you want to get those refreshed, and don't ask me how often, because that's exactly what folk like me talk about when we get together and we have nothing else to talk about. I would say 10 years is too long. I would say 5 years is too soon. So pick your number in between that. It's for two reasons. One, technical changes, both in the financial realm as well as in the healthcare realm, occur. And if it's not covered, it might not be a good thing. Just for example, last year, as a consequence of a court case here in the District of Columbia, we changed all of our language relative to social media, separated it to deal with electronic mail, because the language we'd been using for several years, a court decided it didn't actually allow the agent to read Google Mail. They could get access to it, but not read it. Very weird. So anyway, so then we now have new language. So that's important to do. And then in the medical realm, things happen as well. So, so advances. And also though, think about, you're a teller at a bank and some person comes up and slides a power of attorney, that's one of those really old ones, and says, I want to clean out my aunt's bank account of, oh, I don't know, $300,000. And you're going to go, it's a 30-year-old document. How do I know that Aunt Maba or Uncle Tom wants someone who they gave power to 30 years ago to be able to do this? And so in the financial realm, they want to see much more current documents. All right. Now, your question about your counsel, your lawyer, having moved on. Personally, I do not keep client original documents. It's very old school. There are still some attorneys, but it's really not considered the best practice. It's better to give your clients the original documents. They've paid for them. Make them responsible. If you win the lottery and you want to overnight go to Tahiti for the rest of your life, gosh, you don't want a file cabinet full of documents and have to give them and find out where all these people are now, 20 years after they've been your client. I have a file safe, a file safe, where I have wills from 2 attorneys who quit practicing, one who's now dead. And you know, it's really not the best thing. So hopefully you're in control of your documents. Every once in a while, read them. I don't know, not every once in a while, like every 4 years, read your documents. And if they're still doing what you want, great. Fold them up, you know, put them where you have them safe. And we can talk about where you should keep your own documents. And if what you want to do is make a minor change, you want to give Olney 20% instead of 12%, and you want to give someone else, I guess they get less, you could do that by an amendment to your trust, or you could do that by a codicil to your will. A codicil or an amendment is a separate document that gets stapled to the original document. And notice I said stapled, because if it's physically not found with the underlying document, then it's as if it never existed. And so I recommend to my clients that they get the biggest, thickest, meanest stapler and staple it. You also probably don't want to do an amendment or a codicil if what you're doing is going to change someone's position or institution's positions, and they're likely to the negative, and they're likely to find the codicil or the will or the trust and the amendment before anyone else will. Because they may be tempted if they see that Olney is now getting 8% more and I'm getting 8% less. Unfortunately, there are some people who don't love Olney who might make that codicil or that amendment go away. And then it's the underlying document that rules. So I think I answered your question and then pontificated a lot more.
Thank you.
Thank you. The next question, I believe, is coming from Olney's collection room. Please unmute and state your question. And after that, we have one from Soromne and Sam.
Yeah, hi, Mr. Lars. So my name is Amuhelang, and I had like a question in terms of like wills and stuff. So like I wanted to know, right? What age would I be able to start writing my will from? Or is there like a whole legal process that I need to go through in order to write it and stuff? Or like, cause like, I don't know, it sounds pretty promising to know what would happen to me after I'm not like, well, on earth. So yeah.
Okay. So my Alzheimer's is kicking in because I am forgetting the name of what it's called for a will that's written solely in the hand of the individual who died and it's not witnessed. Holographic, that's not the correct, but there is such a document. So at some point you can actually just, you yourself write out, and some states actually will recognize such document. Not the best idea. Not all states recognize it. Basically, you got to be 18 years of age, and you have to have something like worth it. If not, wait. You know, at some point you're going to have some assets. You know, it's kind of interesting. When do I see clients? I see majority of my clients right before they're getting married and they're contemplating buying a house. That's kind of the sweet spot when I see a good chunk of clients. I do a lot of same-sex work, so I also get a huge amount of my business from people who aren't getting married, who are still partnering up and are buying properties together. But in that realm, you know, I think the marriage numbers are going up, but I still see a big number of coupledoms who aren't married in the same sex realm. I also do premarital agreements, so that may be a consequence of why I see those clients then. The next group, surprisingly, is not those who are giving birth and are welcoming a little papoose into the family. It tends to be after that little thing has grown and they're kind of around knee height that the parents go, oops, maybe I should be thinking about this child or these children and what happens if if we're not around. And so that's when I see another big group of my clients. And then start, keep seeing people through their 30s, 40s, 50s. And then I see them kind of one more time, the retirement period. So they're the ones who, we want to change what we thought we would do for our kids. They're successful, or we were giving a lot to our brothers and sisters and they don't need it, or we were giving to our parents and they don't need it. And so I see a big concentration kind of in that 59 to about 62, 63. And then I really don't see people again. It's very rare that I see people doing estate planning after the mid 60s. So I think you have a little bit of time left, unless you, invent some social media platform or something. And, then you should have an estate right away.
Thank you,
Have an
Lars.
estate, you should have an estate plan, I should say. Yeah.
Next, I think we have a question from Soro and Sam. Can you unmute, introduce yourself and say your question?
Hi, I'm Sam, and it's just me that has the question. But my question is that if you do leave all your money to a lover instead of your spouse, could the spouse sue the lover for adultery?
No, but probably can go after what's called a marital share. So most states have a minimum amount that if the surviving spouse wants to get, he, she, they can claw it back. Goes back, now I'm going to be really sexist, but it goes back to the man has the 6 kids, gets rid of her, and has the mistress and gives everything to the mistress. Maybe not quite your scenario. Yours was much more loving. But public policy, you can't make the 6 kids the ward of the state. And so I'm not aware of a state in the United States that doesn't have a minimum amount that has to go if the surviving spouse wants it. In the District of Columbia, it's 40%, it's 50% elsewhere that I know of, 60% in some states. I think that's a high number. I think 30, 40, maybe more average. So I mentioned premarital agreements. If you think you're going to have a lover, or, hey, let's just recognize that a large percentage of marriages don't work. I think it's kind to do a premarital agreement, because a premarital agreement sets the rules. You establish the rules when you're the most loving, when you think the most glorious thoughts about your future spouse. And if that scenario happens, that marriage doesn't work out, then that roadmap is already there, and you follow that path to the dissolution of the marriage. Now, there are probably going to be some terms that you couldn't have thought of, that you didn't think of, some scenario, but you've already at least determined what the mechanism to resolve that dispute is in a well-done premarital agreement. So I think a premarital agreement you can sell to a prospective spouse as a kind thing to do, something that's a loving act to do. And what do you take care of often in a premarital agreement? You take care of just that issue about spousal support, and it's not that issue. You take care of spousal support, and you take care of your issue. You have each other waive, or you try to generally, if you have the most amount of money, the claim for marital share in your estate. I love doing premarital agreements. They're so much fun to figure out really what matters to couples, where they're coming from. You tend to always have another attorney involved because there's a kind of an inherent conflict if one attorney represents both parties. So it's always interesting to work with another attorney and to see kind of what his or her or their angle is that they approach premarital agreements from.
Thank you, Lars. Thank you, Sam, for the great question. Are there any more questions?
I want to
Right.
say hi. I want to say hi to Kate Haas. I see that she's on, and just let her know that Doug Keith came on ever so briefly at the start before we went live. And Doug is exactly how you figure he would look, except he looks all white.
Oh my goodness. Well, you look exactly the same, Lars.
Thank you, as do you.
It's lovely to help people see each other that have not seen each other for a while. We have another question from Amy. Go ahead, unmute.
Hi, I'm Amy. I teach Metanoia Humanities. I was wondering, when you talked about the fictional books and the fun stories and the movies, what happens when a lawyer, your dead body's on the floor and the lawyer is reading the will and everyone's crying, and another family member runs in with that dirty old napkin from the secret safe in the office, and they say, but this is a real will and the signature is legit and they left everything to me? Then what?
Yeah, fun. I love it. Make some money. Yeah, no, I mean, it's a great scenario for lawyers, you know, and then we're able to make our annual fund contributions to All in Friends School. So there are minimum requirements for a will to be valid. And so you go through, you would evaluate those two documents. There has to be someone who proposes that document as a valid will in contest to the will that someone else says is the valid will. Ultimately, a judge in a probate court is going to look at those documents. So, were there witnesses to both those documents? Did the witnesses themselves have capacity? Did the witnesses themselves witness each other witnessing the testator? That's the dead person sign. Did the dead person have capacity? I can tell you that in the District of Columbia, the probate court hates that question. They avoid getting involved in the mental fitness of the dead person. They'll I mean, they really try not to evaluate that. Other jurisdictions, the judges love to figure out whether the person had capacity. And so in some jurisdictions, lawyers will videotape every execution in order to provide evidence in case there's a challenge. You just don't want to do that in the district. And the problem with that is if you don't do it for one person, then the question becomes why you didn't do it for one person. Or if you did it for one person and not all your other people, and you say you did it because you wanted to establish the capacity, then the judge might say, well, maybe you really did it because you didn't think they had capacity. So, I mean, those competing documents would get evaluated. Fitness, capacity, whether the witnesses really saw it. And then, you know, what often happens, and this is, I mean, this really does not happen that often, but, you know, you've kind of seen it. I'm trying to think that in Detroit, one of the icons of American music, a female singer died, and various purported documents of will were found, including, I think, in a sofa a couple of years after something was probated, and then that was brought to the judge to be probated. What a judge will do, and what he did in this case, was basically get all the family, lock them in a room, get all the interested parties, lock them in a room, and make them work it out. Because you really don't want the judge to be making determinations like this. And it ultimately becomes the party's best interests to try and resolve a dispute like that. And who knows, someone else may die during the process. You know, arsenic works well. Mimi,
Thank you very much,
down?
Lars. Thank you so very much, Lars, for this wonderful talk. Certainly, you have you've gotten us, some of us thinking, but one point's clear. I'm very glad for the 20% you'll send only friend school, Lars.
Good.
You've always been a great supporter of the school. So thank you for committing. And this time we recorded it as you said. So we are grateful. And I'm grateful also for the Quakers who are on this Zoom meeting. I know Quakers are not so comfortable talking about money all the time, but I'm glad to see many of you here tonight, and I'm sure that Lars has inspired all of us. Students with questions, please go through Anne-Marie. I'm sure she will transmit your questions to Lars. And Lars, we don't want to take any more of your time. We are grateful for your support to the school and your commitment as always, and also for always sending me notes on how I could be better. And again, to everyone present, Eduardo, you are there as our trustee. Every mistake I make, please blame on Lars. He was the chair of the committee that picked me. Once again, thanks so much, Lars. We love you, and everyone have a wonderful night. Students, enjoy study hall. It's time for study hall. Please go study.
Thank you,
Good night,
everyone.
everyone.
Good night.